Okay, this is the introductory presentation on pre-contractual obligations for the United Kingdom, which from now on will be referred to as the law of Great Britain. There is no special rule of pre-contractual liability, also known as culpa in contrahendo. It doesn't exist in English law. This means that, unlike in civil law jurisdictions, there is no direct rule or laws on pre-contractual liability in the UK. They therefore have to look for a specific tort, breach of contract, or ground of liability for unjust enrichment. This is the tort of deceit in England and Ireland, and the delict of fraudulent misrepresentation in Scotland. The general rule is that parties negotiate at arm's length, and they look after their own interests, and there are no obligations to the other party. In English law, the main sources of liability would result from fraud, misrepresentation, misstatement, breach of implied contract, breach of confidence, and restitution. In Scots law, these obligations would be to not tell lies, for example, misrepresentation, practicing deception, fraud, or coercing the other party into entering the contract, for example, force and fear of exploiting a special relationship one has with another party, quite separately from the contract under negotiation, for example, undue influence. If any of these factors are present in negotiations, which leads to an apparent contract, only then the contract can be void or voidable. There are remedies available where there is a wrong that resulted, and this will be for a civil wrong. There can be a delictual liability of negligent misrepresentation and fraud at common law, and also when negotiations break down but there has been some preceding transfer of value between the parties, then an obligation to restore any benefits may arise under the rules of unjustified enrichment.
There are clear advantages for the approach used in Britain, and the perceived practical advantage of the conservative approach of English law in its refusal to accept culpa in contrahendo is that this helps English law to retain its special distinctive identity and style as a competitor in the international market of choice of law shopping, even offering a sharper practical conservatism than its greatest common law rival, the New York contract law. It creates a merchant legal system about self-interest, as seen in the Walford case. There are differences in the approaches between England and Scotland. For example, in English law denies the liability for wasted expenditure in cases of failed contracts, promissory and proprietary estoppel being capable of dealing with only a very limited amount of cases. English common law recognises the importance of the freedom to negotiate in business life, but also that there is a need for effective control of abuse. The law deals with it in two ways. First, the courts will go to great lengths to find that a contract exists, and secondly, where this is not possible, the courts will have to come up with a series of remedies available to the injured party through which he can seek redress against an unscrupulous counterparty. Although English law doesn't contain a specific document on good faith, there are various tools that have been used to protect the consumer, such as misrepresentation, or if the contract has been induced, they have the right to rescind, as exemplified in the Misrepresentation Act. Scots law provides an equitable remedy for the recovery of wasted pre-contractual expenditure, but this may only be claimed in the restrictive case where there has been an implied but false assurance by the other party that a contract has been conceded between them. It might go too far to suggest that a remedy is promise-based, and it is a form of voluntary liability. Some say that the nature of the Scots remedy lies in good faith, and which would draw comparisons with other civil law systems. Scotland has a doctrine of law that will give rise to liability for expenditure incurred through the lack of good faith in pre-contractual negotiations, and the exact scope is not clear, but it is from the case of the Bank of Scotland and PLC, and is the idea of an expenditure-based liability arising from implied assurance, i.e. that an agreement was a binding contract seems consistent with an overall basis of good faith, while at the same time manifesting the tendency of Scots law to concretise that concept in carefully defined rules. There is an emphasis on the equitable nature of the liability, which carries with it the risk of a perception and perhaps isn't wholly avoided, as the Lord Cameron said it should be used where there is no other remedy in law. The position is that there can be an agreement which falls short of a binding contract, and there is an assurance for the parties that a contract can be implied from those circumstances, especially in contracts for the sale of land where parties do not fully understand the importance of the legal requirements. In 1999, the UK Law Commission announced it was writing a commercial civil code, and this was rejected.
So pre-contractual duties of disclosure. So this is talking about pre-contractual duties, which are the duty not to break off contractual negotiations, i.e. a duty to continue negotiating in good faith, the duty to disclose such information to the other party in the contract negotiations that the other party needs to know to conduct negotiations. The common law approach said that this interferes with the party's right to seek the most advantaged bargain it can, but this is not consistent with the common law arm's length view of negotiations, which may presuppose an unrealistic level of selflessness and may be difficult to establish in practice. The common law thinking can be seen in the case of Bank Financier de la Cité SA against Scandia UK Insurance Co., where Lord Templeman said that a duty to disclose would result in damages would give rise to difficulties, as the information may be unreliable, doubtful or inconclusive, and this may expose the informer to criticism or litigation. The rationale for having no such duty is consistent with the rationale of common law to impose duties of disclosure on contracting parties beyond that for which is an established precedent. This is contrary to the civil law, which hugely differs from common law here, because they think there's a need to impose duties at this time and to impose duties of good faith, seen in the German Civil Code in section 241 subsection 2. The comparison between the United Kingdom can be seen from the Netherlands, where they have the doctrine of pre-contractual relationship, and this was seen in the case, a Supreme Court case in the Netherlands in 1982, and the approach is seen to be the most progressive among the civil law countries. In this case, the Netherlands Supreme Court held that as a consequence of the requirement to observe good faith under Dutch law, a party breaking off negotiations may be held liable for reliance damages and even expectation damages, or otherwise be obliged to continue negotiations in good faith. Dutch law is not only open to the general notion of a duty to negotiate in good faith, but takes the view that the very nature of negotiations creates a relationship which the law should protect, and states almost merges into the contract itself. According to the Plass and Valberg case, the third stage of negotiations is one which the parties are no longer free to break off, in the sense that if one party does break off, he may be required not only to compensate the claimant out-of-pocket losses, but even to compensate the expectation which he had from the contract. We'll also be comparing the law of the Great Britain to Swedish law, where they also have the culpa and contrahendo as a concept, but this is not really used. The question of qualification for this has been deemed to be a trivial matter because nothing substantial comes from this, and this is a principle that only negative interest is compensated for.
Thank you for listening.